So I am Don Verrilli, and I am the Solicitor General. Argument preparation in this office is a thing to behold. It really is remarkable. It's, each lawyer individually will engage in the initial preparation according to that lawyer's own style. But the real action is at the moot courts, and we require that each lawyer do 2 moot courts for an argument, in preparation for an argument. The moot courts are about an hour of Q&A, followed by an hour to an hour and a half of discussion. There'll be the lawyers who worked on the brief will participate in the moot courts, and then other lawyers in the office will be part of their responsibility is to participate in the moot courts. And then all the other lawyers from the Department of Justice and from the executive branch who participated in the case either at the Supreme Court stage or earlier will come to the moot court. So the moot court and they will ask questions, and typically you're going to have 15 or 20 lawyers, sometimes more. In cases like the healthcare case, we probably had 50 lawyers in the room for the moot courts. And they're really amazing. One thing I found just startling for myself is that 80 to 90% of the questions that I get asked at my oral arguments have been asked at the moot courts, often in precisely the same words that the justices will use to ask the questions at argument. I mean, sometimes I'd just be startled that exactly the same words are coming out of the mouth of a justice that came out of the mouth of one of the assistants at a moot court. And so that allows me in particular, to be way more efficient in getting ready for argument because you just know what you're going to be dealing with, and that's because the lawyers here are so phenomenal in their ability in their understanding of the court, understanding of each justice, their ability to predict what's going to matter in a case and how the issues are going to shape up. And then if you add to that, the other thing that's quite amazing about the moot court preparation here is that you can draw on not only the legal talent of the executive branch, but the substantive expertise of the executive branch. And a good example of that for me would be the gene patent case, Myriad, from last term, where I didn't know anything about biochemistry. I don't think I took any science after I was a sophomore in high school. I need to understand how I need to understand some basic genetics. So I called up Francis Collins, who's the head of the National Institutes of Health, and also happened to be the first head of the Human Genome Project. I said, Francis, I need your help. I need you to come to the moot courts. And so Francis Collins came to the moot courts, and it was incredibly, incredibly helpful. And you get that, and people are not only willing but eager in the executive branch to help us, and they have phenomenal expertise. And so you put that incredible legal talent together with the substantive expertise on policy or science or whatever the factual issue is, and you can prepare pretty efficiently to get ready for argument. And in terms of the ultimate importance of the argument versus the brief, I think I share the conventional wisdom that what really matters is what you say in your briefs. And beyond that, I find it just impossible to know what effect oral argument has on judgments in a case, whether it has any effect at all, whether it has effects on the margin. I just don't know. I just can't tell. Now that I've been in the job 2+ years, I think the 2 traits that matter most to being effective, being a good Solicitor General, are leadership and decision making. I think this is a leadership position. There is a team of lawyers here that was under extraordinary stress and has an extraordinarily important set of responsibilities to carry out, and they need to be led effectively and supported. And in terms of my own involvement in cases, that means figuring out how to strike the right balance between getting involved in cases myself and trusting the judgment and the experience of the deputies and the assistants as to what we ought to be arguing and how, managing but not micromanaging. And the way I've tended to do that is follow an excellent piece of advice that Walter Dellinger gave me based on his time in this office, to look at the docket and figure out what are the 10 or so most important cases. And that'll be a set of cases larger than the cases that I would argue, but it would include the cases that I would argue, and really focus on them and try to get deeply involved in them and get involved early and work with the deputies and the assistants and thinking through and formulating what the legal strategy will be. And then on the remaining cases, essentially trusting the judgment of the assistants and the deputies. Now I review, as Solicitor Generals have done, Solicitors General have done throughout the time of the office. I review every brief that goes in, review and edit every brief that goes in. I tend to get them 3 or 4 days before they're due, in cases apart from the first category I described. And with respect to those, there's not a whole lot you can do in 3 or 4 days. Probably be unwise to try to do a whole lot in 3 or 4 days. And so, I review them and make sure I'm comfortable with them. But in most of the cases, I'm really just trusting the judgment of the deputies and the assistants about the right way to handle the case. And then there's a set of cases that I would say reflect my own personal legal judgment more. And so I've tried to be an effective leader within the office that way, and then I've tried to be an effective leader in the sense of representing this office effectively within the department and within the executive branch to make sure that our position is respected and our role is respected and our views are respected, and I think that matters a great deal. The other thing that I think matters even more, though, is making good decisions. Really, when I take a step back and look at this 2.5 years, it's mostly about making decisions. The SG makes a lot of decisions, from these basic decisions about whether to appeal, to decisions about whether to participate as an amicus, to decisions about how to argue cases. And you got to make those decisions well. And you've got to make them in a manner that reflects the institutional values of the office, the duty of candor that I described earlier, the overall interests of the executive branch. We've got to be careful and prudent, and we can't waste our credibility. But at the same time, I've come to appreciate that there's a real responsibility that goes with making these decisions, and that events are not foreordained. Events can unfold in one direction or another, and the way that the Supreme Court decides a case can have an important effect on whether history takes one path or another. And therefore, the judgments that I make in this job, which may or may not, but may have an influence on the way the court decides a case, its bottom line, or even how it articulates its rationale for deciding a case, could actually really matter in history going down one path versus another. And that's a weighty thing. And it's an extremely rewarding part of the job. It is the rewarding part of the job, really, for me, trying to exercise judgment effectively and make the right decisions for the right reasons. But I do think that is the most important thing that an SG does, is in order to be a good SG, is make good decisions. Make good decisions across the full range of what I described. Yeah, I think that, for me, there's several cases where I feel like I was significantly involved in the process of deciding how we were going to present the position of the United States. Healthcare was certainly one of them, and the gay rights cases from this past term, Perry and Windsor, were also examples of that. And without going into the internal deliberations, which wouldn't be appropriate for me to go into, what I will say about it is that, I did really immerse myself in those cases and trying to think through the best way to present the position of the United States. The way we presented our position, I feel good about, because I feel like it reflected judgments that I thought were the right judgments to make. And so when I look back on this experience, I think I'll look back on those cases, others too, but in those cases and say, well, you know, I really feel like that I did the job in a way that I can feel proud of, and I made decisions that were good decisions.